This meeting is being recorded.
Hi, everyone. Thank you for joining us. We are going to give people until about 6:05 to get started. Please mute yourself if you are not muted. While we wait for everybody to join, I am going to give a quick overview of the format for this evening's webinar. So starting at 6:05, our Executive Director, Zach Sheehan, is going to give a quick background of the New Hampshire School Funding Project and introduce our panelists. And then we are going to get a quick background on the ConVal suit and the RAND suit from Michael Tierney and Andy Walensky, respectively. We will then move into a moderated Q&A that will be moderated by me. We have some questions that our team has come up with together, and then we will move to audience Q&A that will be moderated in the chat. And so the way that that will work is if you have a question, you put it in the chat, and then Noah, our communications manager, will take that question from the chat and he'll put it in a document for me to read from. So if you have questions as we are moving through the presentation, you can put it in the chat whenever you have the question and we'll grab it to read at the appropriate time when it's time for the audience Q&A. In terms of timing, we have about an hour for this webinar. We are happy to stay on a little bit later until 7:10 or 7:15, but not much longer than that. We like to keep people's videos on during these webinars when we have panel discussions, just to make it feel a little bit more personal and more communal, but we will not be giving folks an opportunity to unmute themselves with such a large group. So please bear with us on that. And if you have anything to say, we will all be paying attention to the chat. So with that, I am going to turn it over to Zach to give a quick background on our organization before we move into the meat of tonight's presentation.
Thanks, Casey, and thank you everyone for being here. My name is Zach Sheehan. I'm the Executive Director of the New Hampshire School Funding Fairness Project. We're a nonprofit organization. We've been around for a little over 3 years now, with our roots in the original Claremont lawsuits, which some of our attorneys, John Tobin and Andrew Walensky, were also involved deeply in those lawsuits in the 90s. And so while we may be a newer organization, kind of our history stretches back there. We do a lot of work educating people around the state on how our schools, our public schools in New Hampshire are funded, the way property taxes are used, and kind of the deep inequities baked into both of those systems. We do traveling presentations. We do a lot of work working with volunteers and advocates to talk to their legislators. Some of you might be here this evening. And then we try to do a lot of work talking about and educating people about the various school funding lawsuits and what they mean, how they're connected to the legislative process, and kind of how they fit into the whole picture of school funding here in New Hampshire. So I'm really excited to be joined by this panel this evening. And so I won't take up too much more time here. So we're joined this evening by Michael Tierney, who's the lead attorney in the ConVal school funding lawsuit, which has been going on for about 4 years. And they just wrapped up their trial a few weeks ago, and I'm excited to hear his take on that. We're also joined by Andrew Walensky and John Tobin, who have been lawyers and activists on this issue for decades, and were a part of the the lead legal team in the Claremont lawsuits in the 90s, and really built a lot of the foundation here for the current school funding fights. And also Natalie LaFlamme. So she is a lawyer with Andrew and John on the other school funding lawsuit, the RAND suit that's currently going on. You'll hear more about that. Natalie is a native of Berlin, New Hampshire, and is now a lawyer in the Concord area. So with that, I will kick it over to Michael to get us started.
Yes, thank you. So for those of you who don't know me, my name is Michael Tierney, together with my partner, Elizabeth Ewing. We just finished litigating the case of ConVal and 17 other school districts. This is a case that's going on for 4 years. It is a very important case that in 2021, the New Hampshire Supreme Court remanded back to the Superior Court in order to determine the components and the costs of a base adequate education. And for those of you who might not have watched any of the trial, there's a little summary sheet, Exhibit 17, that if Zach can pull it up, I think you can see what we were talking about for several weeks, the components of providing a constitutionally adequate education here in New Hampshire. These components, as you can see listed over there on the left, are all the things you need to have a school run in New Hampshire. And these components are not local choices. It's not something that one in a locality says, we're going to decide to have a teacher, we're going to decide to have a principal, we're going to decide to have a school counselor. No, as you can see over on the right, all of these components are mandated by the state of New Hampshire, are required components for New Hampshire schools to provide instruction in the content areas that they're statutorily required to provide. If we were to have a soundbite for the trial, the soundbite could perhaps be whatever the state requires a school to provide, it must pay for, because the Constitution, Part 2, Article 83, puts the exclusive responsibility for funding a constitutionally adequate education on the state, not on local communities. Now, during trial, we heard from over 20 witnesses about how all of these components over here on the left on this Exhibit 17 are all lawfully required in order to provide a constitutionally adequate education, but they're also practically required. You can't have a constitutionally adequate education or any education if you do not have these necessary components. We heard from state witnesses as well, who also agreed with us that either they didn't know what was required, or that what was required is what is set forth here in Plaintiff's Exhibit 17. Now, all of these components, of course, have a cost, and the cost was determined a couple of different ways. The least expensive way of determining the cost, Dr. Rizzo Saunders of the ConVal School District did an analysis of each of these components, and prior to the cost of transportation, it's about $9,929 per pupil. Now, this is before you have any of the costs for what we call differential categories, such as special education costs, and other expert witnesses, such as Bruce Baker, who was hired by the 2020 Study Commission, did a regression analysis that came out a bit over $10,000. We had other people from Dr. Dassaw, Dr. Garofalo, Dr. Connolly, who all testified that in particular districts, the necessity of tuitioning had a cost of $14,000 or $16,000 or even $17,000 per pupil just to receive the base adequate education prior to those special education costs. I think it's interesting to know that during trial we heard from a couple of the state's witnesses who none of the state witnesses testified as to a cost different than what the plaintiff's witnesses testified to, though Dr. Castrell, who was one of the state witnesses, had determined the base adequacy cost in Massachusetts approximately 20 years ago, and if adjusted for inflation, would be over $10,000 per pupil. So in summary, and I'm really doing a very, very high level summary of basically what we discussed in our closing argument at the end of trial. But in summary, we're asking the court for declaratory judgment that the components necessary for a constitutionally adequate education are those that we set forth in that exhibit that you all just saw a minute ago, that these are required both as a matter of fact and as a matter of law. that the state is required to provide the actual cost of transportation, including high school transportation. We heard a lot of testimony during trial that all students need transportation in order to have that opportunity for an adequate education. We also heard that the cost of adequate education is no less than the $9,929 per pupil, which is why we're asking the court for declaratory judgment that funding an amount less than that would be unconstitutional, and that the statute that is funding that, that's RSA 19840A2, is unconstitutional both on its face as well as applied to the petitioner school districts. So that is the ConVal school district case in a nutshell. You know, ConVal has been leading this for 4 years, but I would be remiss if we didn't thank all of the partners, all of those school districts that stood up and really worked so hard to make sure that we have a clear understanding of the cost of an adequate education. ConVal was joined by the Winchester School District, as well as the Messina School District, the Monadnock School District, the Fall Mountain School District, the Claremont School District, the Newport School District, the Hillsborough-Deering School District, the Grantham School District, the Manchester School District, the Wyndham School District, the Derry School District, the Hill School District, the Mascoma Valley School District, the Nashua School District, the Lebanon School District, the Hopkins School District, and the Oyster River School District. And I run out of breath just listing off all of the school districts that came together in order to make this all happen, because these school districts are from various parts of the state. They have various backgrounds, they have various geographic, but everyone is in agreement that we need to have the state fund a real world base adequate cost of providing an education.
Thank you, Michael. All right, Andy, you're up.
Hey, everyone. So I'm here tonight with my colleagues and friends, John Tobin and Natalie LaFlamme. Not with us tonight is the pro bono litigation team that we have helping us from White & Case in New York. Our case is in some ways a little different than ConVal and in some ways overlaps. Our trial is scheduled for late September of this year, so we'll work hard on it, getting ready over the summer, and then try it at the end of October, or at the end of September. So whereas ConVal is mostly school districts as the plaintiffs, our clients are individual taxpayers. We've melded together both the requirement of Article 83, which is for an adequate education, constitutionally adequate education, and Part 2, Article 5, which requires that state taxes be uniform across the state. Let me admit at the outset that I am tired of talking about adequate education, and I'd prefer to use the word competent education. The state has a constitutional duty to provide and fund a competent education. So we overlap with ConVal in saying to the court that $3,866, if I were in court, I would say is without factual basis and is low. I will tell you it is an embarrassment. It cannot be defended and is not being defended by the state. So we overlap in that way. We have a slightly different approach to establishing that 3866 is insufficient, but those issues do overlap. We are taking head on the issue of differentiated aid. The state has admitted in its statutes that it costs more to educate children with certain qualifications. Children who qualify for special education services, children who are learning English, children who live in poverty cost more to educate. But as they did with the base cost for a competent education, the state is assigned an arbitrarily low, i.e. embarrassing number for each of those categories, and we intend to challenge that. In fact, we will argue that special education services are particularly important to qualifying children, and that in order to participate in a system that provides a competent education. Those identified services are necessary, and the state ought to pay for them. Right now, the state pays for about 50 million out of a $650 million special education budget. We think it needs to be pretty close to the whole amount. Another area where we do not overlap is, as taxpayers with our clients, we've looked carefully at the statewide education property tax. As I mentioned at the outset, state taxes need to be uniform across the state. Lo and behold, there are communities that do not pay the statewide education property tax. I'm not talking about impoverished communities. I'm talking about gated communities, golf courses, mansions owned by trust funds up north, and they are excluded from paying the statewide education property tax. There are other communities that are well off that only pay a portion of the tax. So we've challenged that. I'd say we've had a real luxury to watch Michael Tierney and Elizabeth Ewing try their case. It's given us some really good insights. I'd say that Judge Ruoff is a very good trial judge. He was a good trial lawyer beforehand, and he knows the topic, and he's paying attention. All of those are really important, but let's be clear. Ultimately, these two cases get decided by the New Hampshire Supreme Court. And so I want to put on your radar screen the fact that Justice Gary Hicks must retire in November, and we should be thinking about and talking about who Governor Sununu will replace Justice Hicks with. So again, our trial is in September of 2023. We appreciate all the hard work that's been put in by the project and by Michael and Elizabeth. And we look forward to giving the state a run for their money in September. Thanks, Casey.
Thanks, Andy. All right, I'm going to take a quick second just to add all of our panelists to the spotlight here. And for the moderated Q&A portion, the first question I have is for Michael. Michael, ConVal has argued that a base adequate education costs $9,900 per student, more than 2.5 times what the state provides. Do you feel it is likely the court will issue a ruling that requires a specific base adequacy amount? And if they don't issue a specific number, what would a favorable outcome look like?
So thank you. Your question that you ask is actually extremely similar to a question that Judge Ruoff asked at the trial management conference in March. And he specifically asked us to address that very question in a supplemental briefing. So we submitted a supplemental memorandum on March 31st that addresses that very issue. And what we said in that memorandum is that the issue of determining the components and the costs is something that the Supreme Court has said must be determined by the trial court in the first instance. In the Supreme Court's remand, they use the word must. That is what this remand order is about. And so Judge Ruoff of the Superior Court in Rockingham County has been told by the Supreme Court that that is what he should do. Now, why is that something that he should do? Why is that not something that should be left to perhaps somebody else? Well, the text of the Constitution, the text of Article 83 of the Constitution, assigns the responsibility to making sure that an adequate education, or a competent education, as Andy had phrased it, is the duty of the legislature and the magistrates. It's not something that is just assigned to one branch of government. It's assigned to the entire state. The entire state, including the judicial branch, must enforce the constitutional right to a state-funded adequate education. And that is absolutely, positively what we're expecting the court is going to be doing, as the Constitution not only requires, but as the Supreme Court has instructed the Superior Court to do.
Fantastic. Thank you, Michael. For the RAND team, Judge Ruoff will be presiding over the RAND case in September. After watching the ConVal trial in his courtroom, did you gain any insight to how the court might view your arguments?
So I'm happy to jump in on this one. I had season tickets for the ConVal trial. I was there almost every day, and it was very inspiring in lots of ways. The state's sort of convoluted and not substantial arguments were very infuriating. Judge Ruoff, as Andy said, was really paying attention. He understands these issues. He seemed very skeptical of the state's arguments that many of the things that were listed on Michael's chart, in fact, are not necessary for an education. The state struggled to admit that teachers were necessary or that buildings were necessary. And the judge was very skeptical about that. And it's also really clear, and the judge spoke about this, the state is not trying to defend the current numbers. Their whole approach is to try to knock down any argument that anybody else makes about what the number should be. The state has no defense. As Michael said in his closing, they're indefensible. The current standards are indefensible. And so the state is not trying to defend them because they have no expert who can say that those numbers are right. So I think the judge understands all of that. And so I think he's primed to listen to our arguments about special education and the other differentiated aid categories. I also think we've seen him in at least one argument talk about the tax issues. And I think he understands those issues as well. He has said pretty much that they're not really factual questions. And so we feel pretty confident that if he knocks out the current adequacy standard, which we think he will, then there's really no way he cannot knock out the current tax system with its really disproportionate tax rates from town to town. So, I want to really pay tribute to Michael and Elizabeth Ewing and all the school districts. If you had been there, you would see Michael and Elizabeth presenting their case, and 3 lawyers from the Attorney General's office and 4 lawyers from the Missouri law firm that the state hired. So the state had 7 people up there trying to defend the undefensible. And I think the judge saw through a lot of that. And it makes me feel that our case will also be heard in a fair, thorough, intelligent way by him.
Natalie and Andy, do you have anything you'd like to add?
I defer to Natalie.
I echo a lot of what John said. I will say, I think the most interesting thing watching the ConVal trial was, just kind of seeing the state do a defense that wasn't a defense at all. And I think it gave us more insight in what they're going to argue. And I think it just gave a little clarity. The judge was asking, it's a bench trial, so there's no jury. I forget if they mentioned that. So the judge kind of was asking some questions as well. And at one point, he just got the state to admit, are you just saying this is like a hypothetical bare minimum number compared to how things actually work in reality? And the state was like, yes. So they're completely dealing with hypotheticals, what things cost. And I think that was quite interesting to just see the state have to point blank answer some of the judge's questions. So looking forward to seeing them flail again in September.
I too enjoyed watching that. For the entire panel, I have 2 questions left before we move into audience Q&A. During the trial, the state argued that courts have no role to play in the school funding challenges that New Hampshire faces. In a perfect world, how would you see the court rectifying the state's lack of accountability in fulfilling their constitutional responsibilities? And I'll leave it up for anybody who wants to jump in there first. Just go ahead and unmute yourself.
Go ahead, Michael.
Yeah, I think Michael should answer that. He just argued it.
So I think I already
He argued
addressed
it
that.
well.
that the duty to provide adequate funding for education is not something that is limited to one branch of government. It is an obligation of the entire state of New Hampshire. It's an obligation that is the exclusive obligation. I was just pulling out one of the Supreme Court's previous rulings where they said, I'm going to quote the Supreme Court because they say it better than I can, that Article 83 imposes upon the state the exclusive obligation to fund a constitutionally adequate education. The state may not shift any of its constitutional responsibility to local communities. We argued in our closing argument in the ConVal case that the Supreme Court meant what it said because the Constitution requires that the state bear that exclusive obligation.
So if I can jump in, or
Go ahead,
sorry.
Natalie.
Yeah, so a lot of this goes back to Claremont itself. The state, these cases have kept going to the state Supreme Court, and it keeps deferring under the idea of separation of powers. If you remember back to elementary school or Schoolhouse Rock, separation of powers, judicial, legislative, executive. So it's the legislature's job to define and fund and figure this all out. And so the court keeps saying that over and over and over and over again for 30 years. And it's kind of at a certain point, like, not working. So just for kind of background, there's a lot of these school funding cases throughout the past few decades in a lot of different states. So some states have been a little more extreme in what they've done. There's plaintiffs who have asked to fine the legislature, basically, set up like a trust fund escrow, and every day that they pass the deadline of not fixing their school funding system, the fine goes there. Some states have shut down schools. I think here today, we are not advocating for anything so extreme, but we would really like to see the court have an order that actually has some teeth, give a deadline, do something, set a number as a placeholder till the legislature gets it together. Anything at this point will take literally anything more than the court's done for the last 30 years.
So I'm just going to jump in here because I think that the ConVal case is different than many of the cases that you see in other states and many of the cases that we have seen in New Hampshire previously. Because in the ConVal case, we are not asking that the court order something as far as educational policy. We're not asking that the court set that schools need to be improved by having this, that, or the other thing. New Hampshire schools are doing a very good job, and the state has a very full set of requirements for what schools must do. The state's just not paying for what they're requiring.
So if I can follow up on that.
Oh, go ahead, Andy.
Yeah, I'm such a cynical jerk sometimes. It's not lost on me that the State Board of Education is now proposing to modify the minimum standards. So Michael's case, part of our case, says you put out these minimum standards, we have to follow them, you should be paying for them. The state's response, Edelblue and Drew Klein, are saying, maybe not so fast, we're going to remove minimum standards. So when the Board of Education comes to your community and does their traveling road show, rewriting Ed 306, you should show up and ask why they're doing it and how it impacts a competent education and the state's responsibility to pay for it.
That's exactly right. I just want to build on that and say, this is a multi-front campaign, and the two lawsuits are the biggest and most powerful right now, but we really need to keep the pressure in public on the Board of Education, on the legislature. And so that's a lot of what the project is trying to do. And before there was a project, Andy and I and Doug Hall and other people traveled around the state to try to tell people, explain to people how unfair the current system is and try to get them to talk to their legislators. And so as these cases proceed, we all need to keep the heat on the State Board of Education and the legislature. And that's democracy, that's civics, that's the kind of stuff we have to do so that when we get these good Supreme Court rulings we hope to get, the legislature is primed, they're informed, and even if they're reluctant, they feel the pressure from the court system and from the public to make change.
This is a great segue into one of the questions that we got from the audience early on in the chat. If unless anybody else has something to add to our question, does anyone have any final comments before we move on? No? Wonderful. So I'm going to combine these two questions from Janet Ward and Leslie Want, two of our wonderful usual suspects and advocates. The state is rewriting the Ed 306s and eliminating a lot of the guardrails in place to make sure that we have some assurances of what is required for an appropriate education. Are our panelists, number one, familiar with the proposed changes? Can I just get some head nods? Do we all know about the 306 changes? Yes. So first, will the proposed changes to the Ed 306 rules impact these lawsuits? And Leslie's question is specifically, do you believe this will impact the state's case? So we've got a kind of more broadly, will the 306 changes impact the lawsuits and specifically the state's case? So I'll go ahead and open that up.
And I'll jump right in first here and give a pretty strong and emphatic no. And, the Ed 306 rules that you saw in, Exhibit 17 earlier, those really go to the cost components, that you need to have teachers. You need to have a facility. You need to have, the required personnel. My understanding of the proposed changes is that we're still going to have teachers. We're still going to have facilities, and these still have a cost. And so, even if the rules were to be changed and it was to be said, oh no, you no longer need teachers, you no longer need schools, you can just not have any requirements whatsoever. It's not just lawfully required, it's also practically required, it's logically required. You need to have teachers, and teachers need to be paid. They need to be paid a salary as well as benefits in order to have them be employed in order to teach. And so if a rule change was made that, oh, no, we're not going to require schools to do anything whatsoever, which I don't think anyone's even proposing that, but if that rule change was adopted, it still wouldn't change the practical necessity that you need all of these things in order to run a school, both practically, as a matter of fact, even if it wasn't also lawfully required.
I add in one sentence, the Board of Education doesn't have the authority to rewrite the Constitution. They can change the rules that they have to set up some of the details of how schools operate, but they can't, by messing around with those rules, change the constitutional duty the state has.
Yep. Anyone else? Michael covered it. I had a question that I wanted to ask. Commissioner Edelblue earned a lot of attention as a witness in the ConVal trial. Were you surprised by anything in the commissioner's testimony? And what are the biggest takeaways folks listening should know about? Let's hear it. Come on.
Yeah,
I'll start again
Michael.
if you'd like me to, because I think that the testimony about the analysis that the commissioner did a number of years ago as far as the cost of running district schools as opposed to the cost of running charter schools. Shows that, the commissioner understood that there is a cost of running district schools. His own analysis showed, I think it was about $15,000 per pupil. I think the court heard loud and clear, that there is a cost, and that the commissioner knows that that cost is about $15,000 per pupil.
I would say just, generally, like if you just tuned in to those little bits, not having much background, it just really felt like he was trying to be evasive and unhelpful. Allegedly, I'm not saying he was, that was just the vibe. Really like the position is just, well, we haven't done that analysis. We don't know. And I think the judge, correct me if I'm wrong, other people who were watching it kind of got a little pushy with him. Like, what do you mean this isn't your job you're the Department of Education. How do you not know what an adequate education costs? So I don't think he came off looking great. And I think it just did that undercurrent we've been talking about of the state really can't defend this. And they have no affirmative case that, yes, we are funding an adequate education. Yes, this is what it costs, because they don't have that. And I think that really came across just watching the commissioner.
I agree. I was sitting there that day, and I think he really hurt the state's case. I think, going through when Michael asked him if he'd done any study about the cost of adequacy, and he said no. And then Michael asked, has anybody at the department done that? And he said no. And that's just ridiculously irresponsible, given that this issue has been in front and center for years. And I just watching the judge's reaction, as Natalie said, I think the judge really did not find the commissioner credible.
All right. I have a question from John Lambert that I think is similar to something that we asked during the moderated portion of the Q&A in regard to what can the state really do to enforce. Excuse me, I'm so sorry. So I'm going to read this off. After so many years of court-ordered equitable funding by the state, what can hold the legislature accountable to act on the funding issues, such as fines or lockup, so jail time to those who are accountable? So since the legislature and governors have not followed through with court orders in the past, what, if any, are some of the ways that the state could be held accountable by the courts in the future if these lawsuits go the way that we're all hoping they do?
Y'all could stop re-electing them. That's a start.
Fair.
I'm serious. This has to be a priority issue. You have to ask your legislators, ask the people who run for governor what they're going to do about it, and most importantly, where the money's going to come from. There's been decades worth of magical thinking where political leaders have said we can fix everything and we don't need to address revenue sources. That's not right. And so putting the pressure on, keeping the pressure on. The Supreme Court was very good in its Claremont 2 order by giving the state about 15, 16 months to design a new system and then saying the school funding system stops. That affected our bond rating. Unfortunately, it led to teachers getting pink slipped because the legislators didn't do their job. They spent all their time trying to amend the Constitution. And that's been repeated by both Democrats and Republicans. And so it's really, we can do the legal part. I think this group does it really well. You got to do the political part. And that really goes to electing people who will make a difference.
If I can just kind of like reinforce that and say, just because we're doing these lawsuits doesn't mean it's going to necessarily fix everything. We still need that political side and that political pressure. You've probably picked up on the wheels of justice move pretty slowly. Michael filed this case 4 years ago, and we're still here. And I don't know if we've talked about overall timeline, but it's going to be a few more years probably before it gets appealed and the Supreme Court makes a decision. So it'd be much more efficient if people lobbied the legislature, if you, I don't want to say harass your reps, but like, go ahead and harass your reps. It just needs to be done. And we're, like Andy said, we're doing our best in the courts, but we could use some out-of-court assistance as well.
I agree with that. I think the court, if the court felt that there was more of a groundswell in the public to support, more stern approach to the legislature, I think that might make it easier for them. They have to, Natalie rattled off before, fine the legislators, give them a deadline and put in the court's own number as a default until they come up with the answer. Close the schools. There are drastic remedies. And you could tell from some of the comments that Judge Ruoff made, he's thinking about this. He understands the whole notion of judicial deference, but he said something about this has been going on for 30 years and the state hasn't done anything. So he's mindful of that. And we hope that he has he and then the Supreme Court have the determination to really keep the state's feet to the fire. But as Andy said, we need to keep the other two branches of government's feet to the fire.
Yeah, absolutely. And just while we're on the topic, I will take this opportunity to, number one, clarify that the School Funding Fairness Project is a nonpartisan, nonprofit organization. However, the majority of the work that we do is working to connect the folks like you who are on this webinar to not only your state reps, but also the other folks who are in your community who are passionate about this issue, whether they know it or not, meaning people who are frustrated with the quality of their public schools or people who are frustrated with their property taxes and either don't know why or don't know what to do about it, or maybe don't have the tools to talk about it. So as Zach mentioned at the beginning of this webinar, part of what we do is we go around the state and we do these presentations to help educate folks about what Andy and John and Michael and Natalie are talking about tonight with the lawsuits, and also about the issue in general regarding school funding and property taxes, and who makes the decisions and who's accountable and who's responsible, and how we can work together to fix it. So with that, we have a gubernatorial election coming up. The last time we had a big opportunity to fix this through the legislature was in 2018. So that's all to say that when we have these big elections, that's when we have an opportunity to kind of swoop in and let these folks know who they're accountable to, and that is to the folks that vote them in. So I am just here to say, sign up for our newsletter and follow us on social media so you know what we have going on, and the opportunities that we have to provide for you to help us all work together to make this change together. So moving on. The next question for, I have one for Michael, specific to the exhibit that you shared with us before, relevant to building aid. So I'm just going to pull it back up. In exhibit 17, Christine Conroy, this was the first question that was asked, so I just wanted to make sure we got to it. Christine Conroy was wondering about building cost, and noted that exhibit 17 does not include it. Is it accounted for elsewhere?
Very good question. So The cost of actually constructing a building is not included anywhere in Exhibit 17. And the reason why it's not included anywhere in Exhibit 17 is because a portion of building costs are some years covered by a separate statute, separate than base adequacy aid. The number is escaping me. I want to say it's 198.15A, but I could be off by a number there. There is a building aid program where the state provides a percentage of aid to municipalities for the building of school buildings. And so the actual construction cost wasn't ever intended to be part of base adequacy. Though, as we heard from several witnesses during the trial, the building aid doesn't cover the entire cost of constructing a building, which means that the local taxpayers are responsible for bonds of millions upon millions of dollars.
Wonderful. Thank you for that clarity. So next up from Leslie Want. Did the legislature's funded education funding commission report come up at all during the trial? Leslie noted there were a lot of excellent findings in that report, and there was a significant amount of money funded into that commission meeting. So was it brought up?
Yes. So there are 3 legislative study commission reports: a 2008 report, a 2018 report, and a 2020 report. All 3 are exhibits in trial. And the 2020 legislative study reports general findings were a large part of Dr. Bruce Baker, one of the school district's experts' testimony in the case. He talked about how using his regression analysis, the costs of providing an adequate education separate from special education costs is over $10,000 per pupil.
Great. All right, just bear with me for one moment. I'm having a little bit of trouble with my document. Okay, this question is geared more towards the RAND team. Could the court rule on tax without figuring out an adequacy number?
Natalie.
We'd like the court to. So the way these issues are kind of tied up, just for background, is the state does provide that little tiny amount of funding that we all know isn't enough. And the way that they say it's okay tax-wise, because taxes have to be uniform in rate in the state, any state tax. So they say, oh, well, that's how much it costs. And we have this statewide education tax that is the same rate across the state. So all good. And what happened, ConVal, the first time around, when the judge issued his order and then it went up on appeal, he said, I can't decide the tax issue because I struck down the funding, and we have to know the funding amount before we know if the taxes are proportional or not. Because if the state's right that it's just that tiny little bit of funding, very technically, yes, maybe it's uniform. So we've kind of come up with that of, well, its adequacy is a lot more complicated than the tax thing. Either tax rates are the same or they're not. And if adequacy does in fact cost any more than that tiny little adequacy number, then the tax rates are not uniform and it's unconstitutional. And we know, if you've seen any of the project stuff, tax rates are totally not uniform in the state. So our case, Andy mentioned these briefly at the beginning, we kind of split ours out into adequacy and the tax issue. And we've actually already filed for summary judgment, which means the court decides an issue without needing to go to a full trial. And we really isolated some of those swept things that are unconstitutional no matter what. So it's the negative rates. I think Andy mentioned that there's a lot of unincorporated places in the state that actually don't pay the statewide property tax at all because they're offset with local negative rates. And then there's the towns that have a lot of property wealth, so their swept raises a lot more and they keep it, so it doesn't all go to the state. So those two issues, if you just look at them, they're unconstitutional no matter what adequacy is. And so we would really like the court to deal with that first, because it's clean, it's obvious, it gets at things without needing to go through all of adequacy. But in the past, that's why the courts have linked them up and said, you have to figure out adequacy before you figure out taxes.
All right. Thank you, Natalie. Okay, so with about 5 minutes left, I think it is safe for us to say a few closing words. So if our panelists could go ahead and do that. John, I will let you go first, if that is good with you.
Sure. I guess I would say I'm optimistic that these cases are going to turn out right. Just watching the ConVal trial and seeing a good judge pay attention and really get it, I'm optimistic about that. However, it's really important that we all keep on our work as citizens by ourselves and through the project to keep getting the legislature ready to make the big decisions they're going to have to make when we win these cases. And I think, I guess I would also just say, in terms of what's going on right now, it was pretty inspiring to see all those local school officials from around the state talking about how much they care about their kids and how hard it is to take care of them with the peanuts the state provides. And so that kind of inspires me to keep going with this. And I think, again, I think we're in a pretty strong position legally, and we all need to work together to get into a strong position politically.
Andy?
So no one ever accuses me of being Pollyanna, but I just want to touch on some good things. When we filed Claremont, New Hampshire was last in the nation in state funding, and you could triple the funding and we'd still be last. We're last, but you can't triple it anymore. More than that, you can see when there is something to rally around, like ConVal, like the Rand case, people show up. This is an important issue. So you have the culture wars attacks on education. This is the structure of education. How are we going to pay for it? And people show up. And the relationships we've all created around this issue, the people we've met, the people who show up and make waves when they have to, has been quite gratifying. So it's my hope that between ConVal and us, we give the legislature and the other political leaders the opportunity to do the right thing, and that you all keep watching.
Thank you, Andy. Natalie?
So this has all been inspiring. So I'm just going to talk about random things that just popped into my head. So a lot of the kind of arguments of why we can't fix this system is, no new taxes. So you'll see all the time people say the only way this can get fixed is with an income tax. So it's dead in the water. Number one, maybe people will come around on the whole income tax thing, but number two, it doesn't have to be. And the commission report that we mentioned before, it offered a couple different fixes, and it wasn't an income tax. It was still based on the property tax. It was just a more fair proportional property tax. And the second thing of that is a lot of people have this knee-jerk reaction when they hear, oh, the state needs to fund education more, of, well, now I have to pay more. Not necessarily. You're already funding your schools. It's just falling on the local communities disproportionately. So we're just asking the state to do it, which spreads it out. So those are kind of just reactions people have. And now, you can tell them, no, that's not true. We don't need an income tax necessarily, and your taxes aren't necessarily going to go up.
Wonderful. So Michael, I know everybody has one burning question for you before you give your closing remarks. So if you could include in yours when we can expect a ruling, that would be wonderful.
We can expect a ruling much later than we would like. I can say that with 100% confidence that we will not get a ruling as soon as we would like. But one thing that we have talked about in this trial multiple times is that we have done the analysis to get to the most conservative real world costs. Okay, so the most conservative real world costs of providing a base adequate education. There's going to be places where it costs more. There's going to be places where, due to extra challenges, there's extra needs. But we're trying to get that universal cost, that most conservative real world cost. And that's what courts do all the time, is determine based on the facts and the law what something actually costs, the real world base universal cost. And I don't believe we've had in New Hampshire, at least, a determination of what it really costs to provide a constitutionally adequate education. And I think that is exactly what the ConVal case is all about, is having that determination that the components are what we see in Exhibit 17, the cost is what we see in Exhibit 1.
Great. I'm going to take everyone off of the spotlight here just so we can all see each other as we say goodbye. So I'm going to say one final quick thank you to all of our panelists. I appreciate you all working with me and our organization to provide this resource to our advocates and our supporters. And to our advocates and supporters, thank you for always coming to these to learn and be present with us to, be more educated in your community and to help us in this fight. So I will be sending this recording around to everybody who registered. We will have it available on our website as well. If you have any questions, you can always email Noah and I. Our contact information is on the website. We are always impressed at how many people come out to these, so we hope to be able to continue to provide resources like this in the future. And with that, thank you all for coming. We are ending right at 7, which is amazing. So goodbye. Thank you, everyone.